Hey everyone, today we're going to discuss the law of agency in Singapore, a crucial area of law that impacts many aspects of business and personal dealings. Whether you're a business owner, working in a company, or simply dealing with contracts, understanding agency law is key to avoiding legal pitfalls. We will break down what an agent is in law, the different types of authority an agent can have, and whether the acts of an agent are binding on the principal. So what is an agent in law? Simply put, an agent is someone who is authorized to act on behalf of another person or entity, known as a principal. The agent can negotiate or enter into contracts with third parties on behalf of the principal, creating legal obligations between the principal and the third party. In Singapore, the law of agency is rooted in common law principles and has been influenced by both English law and local statutes. It applies to many situations such as partnerships, employment, real estate transactions, and even everyday purchases where somebody acts on your behalf. The authority of an agent can be classified into three main types. Number one, actual authority. Actual authority is the clearest form of authority. It is the express or implied permission given by the principal to the agent to act on his behalf. For example, if a principal tells the agent, "You have authority to buy and sell property on my behalf," that is actual authority. Any actions taken by the agent within the scope of that authority will bind the principal to the third party. In Singapore, actual authority is recognized by the courts where there is clear evidence that the agent was empowered to act on behalf of the principal, either through explicit words or actions that imply such authority. The second type of authority is apparent authority. This type of authority is not explicitly given, but arises when the principal's conduct leads a third party to reasonably believe that the agent has authority to act on the principal's behalf. For example, if a principal consistently allows an agent to represent him in certain transactions, even without a formal agreement, a third party may assume that the agent has authority. If that third party acts on this assumption, the principal could still be bound by the agent's actions, even if the agent was technically acting beyond their actual authority. The third type of authority is ostensible authority. Ostensible authority is often used interchangeably with apparent authority. However, in practice, it refers to situations where the principal has explicitly made representations that the agent has authority, leading third parties to believe that the agent can act on behalf of the principal. An example of ostensible authority would be if a principal appoints an individual as their general manager and gives them business cards and official titles, which then represents to third parties that this person has the authority to act on the principal's behalf. The principal may be bound by the acts of this individual, even if they step outside the boundaries of actual authority, as long as the third party's belief was reasonable. Now, the big question, are the agent's acts binding on the principal? The answer depends on the type of authority that the agent is exercising. Here's a breakdown. If an agent is acting within the scope of the actual authority, the principal is legally bound by their actions. The agent is effectively an extension of the principal, and any agreements they enter into are enforceable against the principal. If an agent exceeds their actual authority, but has apparent or ostensible authority, the principal may still be bound by the agent's actions. However, the third party must have reasonably believed the agent had such authority, and this belief must stem from the principal's conduct. The Singapore High Court has held in several cases that a principal was bound by the acts of the agent, even though the agent lacked actual authority, because the principal had created the appearance of authority. On the flip side, if an agent acts without any form of authority, the principal will not be bound unless they later ratify the agent's actions. Ratification means the principal retrospectively approves or accepts the actions of the agent. To sum up, an agent can act on behalf of a principal, but the nature of their authority, actual, apparent, or ostensible, determines whether the principal is bound by their action. Actual authority is direct and clear, whereas apparent and ostensible authority rely on the perception of the third party and the principal's behavior. If you're a principal, it's essential to clearly define the scope of your agent's authority to avoid unintended consequences. Thank you for watching. Don't forget to like, share, and subscribe, and I'll see you in the next video.